Okay, we're going to go ahead and get started. I'm going to call on Representative Byrd to open us up in a word of prayer. What number are you, number 13?
13, it doesn't work. If everyone would kindly bow their head, please. Most gracious Heavenly Father, thank you for this day and for granting us the opportunity to be in your divine presence. Be with each and every person in and around this Capitol. Watch over families as we do the people's work and give us traveling mercies to and from the Capitol. I ask that you grant us clarity of mind, wisdom to understand, so that we may make decisions that are right in your eyes. We recognize that every action we take sows seeds for tomorrow and for future generations. We ask all these things in Jesus' name. Amen.
Okay. Well, welcome out, everyone. Honored guests, judges, DAs, defense lawyers, thank you all for being here. Glad to have y'all. Just a note, real quick. There are some changes still being made between the bill author and some folks helping with Chairman Lisa Hagan on House Bill 1142, so that will be moved to Wednesday. 1142. And at the request of Chairman Rob Leverett, we're removing House Bill 997. And we'll try to hear that on Wednesday. First up, we're going to have House Bill 1324. I don't know if Ridley's here yet. Okay. We'll come back. We'll come back. All right. Then we'll go with House Bill 421, Representative Taylor, who has spent the most time with Judiciary Non-Civil out of any member of this session, I believe. So come on down.
Mr. Chairman and committee, I appreciate all the help that you have been to try to perfect this bill. I'm working off of a sub LC 481780S, and we've cleaned it up, made it so simple and easy. This has to do with traveling from another state for the purpose of molesting a child or indecent acts. And what we did under Section 1 of 16-6S5 added the simple lines of or taking a child under the age of 16 to any place whatsoever or travels from another state for the purpose of child molestation. That's just adding it to the code. It had been left out, and this will clarify it.
Thank you, Chair Lady Taylor. Thank you for those that helped us get this amendment. I appreciate your long-suffering patience as well. All right, so let's see. I have several, just one. Robert Smith with PAC. Do you want to testify?
Answer questions.
Okay. All right. Any questions from members of the committee? We'll have to come back on that one. We've got members at other committees, so we'll vote it once we get back to voting power. We're going to go ahead and go through here, and so we'll come back to you.
Okay.
All right. Next up, Representative Hilton, Scott Hilton. Come back. Representative Lupton. Okay. Well, I'm going to go back to Representative Jason Ridley, House Bill 1324.
I don't even know where my man is. Oh, Lord.
Come on down.
There, I hear you. All right. Been over in education, so they got me warmed up for y'all.
Go ahead when ready.
All right. All right. Thank you, Mr. Chairman. We're on House Bill 1324, LC 394953. Everybody got that one? All right. All right. I'm going to let my man here take over because this is a little bit above my pay grade. He can explain it better than I can.
Yes, sir.
Mr. Chairman, members of the committee, my name is Knox Williams. I'm with the President and Executive Director of the American Suppressor Association. Today I'm testifying in support of House Bill 1324, which seeks to remove firearm suppressors from the definition of dangerous weapons in Georgia statute. Suppressors are hearing protection devices, plain and simple. Can y'all hear me? Is that coming through? Okay. You can call them a muffler, a moderator, a silencer, or suppressor. These are all terms to describe the exact same thing. A vital tool that helps protect the hearing of hunters and law-abiding gun owners who simply want to exercise their constitutional rights without permanently damaging their hearing. Suppressors are currently legal to own in 42 states and are legal to hunt with in 41. It is critical to note that no device can silence the noise of a gunshot. Physics simply will not allow it. However, suppressors absolutely reduce the dangerously loud noise produced by a gunshot to safer sound levels. According to Dr. William W. Clark, the director of Washington University School of Medicine's program in audiology, the most serious threat to hearing comes from recreational hunting or target shooting. That is a direct quote. Multiple studies have found that between 70 to 80% of hunters never wear earplugs or earmuffs, and nearly half of all target shooters don't consistently wear traditional hearing protection. That's why the CDC, the National Institute for Occupational Safety and Health, the National Hearing Conservation Association, the Academy of Doctors of Audiology, Doctors for Responsible Gun Ownership, and the American Academy of Otolaryngology, Head and Neck Surgery all recommend the use of suppressors as a tool to mitigate preventable hearing damage. I'm happy to read out a lot of direct quotes from studies from these different organizations, but in the interest of time, I will leave it with that. However, it is critical to note that even with traditional hearing protection, there are many instances where it is not safe from an auditory risk perspective without the use of a suppressor. Access to suppressors is indeed a matter of public health and safety, and this legislation simply seeks to ensure that law-abiding Georgians maintain their ability to purchase and possess these safety devices regardless of any potential future changes in federal law. For these reasons, I ask that you support House Bill 1324 and vote for its passage without delay, and would be happy to answer any questions.
Looks like you got one from the party Jackson over here. Hold on a second. Number 7, Representative Roberts.
Thank you, Mr. Chair. So help me out. Regardless of state law, currently federal law says that you can register under the National Firearms Act a suppressor. Is that correct?
That's correct.
Okay. And that requires a background check and I think a $200 tax is what I read, correct?
Well, I can tell you on this, my son builds these things, so that's the reason I know a little bit. So currently the tax has been taken off in the big beautiful bill, so you don't have to do that. So actually what you have to do, you have to set up a trust, and then you can own that through that trust. So that means every time you go buy one, you have to do your fingerprints, you have to go through the whole process. It takes about a month for it to come through, and then it's almost like a serial number is attached to your name.
Okay.
I can't ever buy it from you. You can't. That's for the trust. If you have a child, you want to move it over to them, then you can add them to that trust. But it can't ever be sold or anything. So it's connected just to you through the ATF.
Okay. And so under current law, you could do that if I mean, let's put aside that there are lots of other ways to protect your hearing while shooting than suppressors. But under current law, you could go through that process regardless of this bill whatsoever, right?
Yes, but I think there was a change. There was one change that all states are having to do this because of some language variation whenever they came out with doing away with the tax stamp.
Okay, but your bill, what I read, because federal law is what federal law is right now, it would eliminate a state law charge that carries up to 5 years in prison if you possess a suppressor. That's my understanding of what you're changing in the criminal code.
Mr. Chair, yes, ma'am. So to clarify, in order to purchase a suppressor, you do have to go through the National Firearms Act. You can purchase either as an individual or through an NFA trust, which is what Representative was discussing there. As of January of this year, you are no longer required to pay the $200 tax that had been in place since 1934. And really what this legislation is seeking to do is just make sure that it complies, Georgia statute complies with any changes in future federal law. When you talk about the availability for other types of hearing protection. I've got a direct quote from the Academy of Doctors of Audiology, and in one of their studies they state, while the use of conventional hearing protection tools such as earplugs and earmuffs are fundamental for preventing noise-induced hearing loss in firearms users, conventional hearing protection alone does not always offer adequate protection from noise exposure. Firearm noise suppressors can be an effective supplement to traditional hearing protection. So from our perspective, this is kind of like saying, well, we don't really need seatbelts because our cars already have airbags. A comprehensive approach is one of the most effective ways that CDC, NIOSH, ADA, NHCA all agree makes the most effective way to help protect, in essence, one of our five hearing senses.
So I'm not arguing with you. We could get into that argument about the balance of public safety and the fact that it's harder for law enforcement to identify active shooters or other things. We could get into that argument. I'm really trying to drill down on the fact you just said it's a preemptive bill anticipating some change in federal law. What I'm trying to get at is tomorrow, if this bill passes tomorrow, the only person that I can see that benefits from this law is the criminal who now will no longer be charged with an enhanced penalty if he commits a crime with a gun. Otherwise, this is just preemptive, assuming federal law is going to change. But rather than a legal law-abiding gun owner can go through these other processes you guys have just said are available, this bill only helps the criminals.
Mr. Chair, may I respond?
I'll remind members this is question period. I'm more than welcome to discussion later on, but keep it to questions at this point. Number 6, Representative Neal.
Thank you to the chair. Hello to the author.
How are you?
Doing good. So I guess my first question is, what has triggered the need for this bill? Because even for myself, and shooting is a sport. It's an optional activity. What has triggered the need for this bill, being that we do have ear protection that's available for everybody?
Representative Neal, hole in state law.
Okay. Thank you to the chair. Additionally, is it not true, or do you believe, because you mentioned hunters and how 70 to 80% of them don't use ear protection. Do you believe, and you let me know how you feel, if you can't handle listening to the gunfire, that you probably shouldn't hunt, or you probably shouldn't do the sport if you can't handle that? Because we've been hearing this we've been having this situation since the beginning of shooting. Like it's one of those things, you understand that even with putting your earmuffs on, there's a certain level that you're going to have to endure if you are going to choose to do the sport of shooting. That was a question.
Well, I would answer that like this. A lot of my uncle was a state trooper. A lot of those guys have, even today, their ears ring constantly. Some of them so bad that they actually went and had it cut to where they're just completely deaf because it rings constantly. As far as a hunter wise, I mean, it's hard to hear if you're hunting deer or squirrels or whatever you're hunting. It's hard to hear them coming if you got hearing protection on. So a lot of times you don't have it on. Well, you don't ever have it on because you can't hear them. But then when you fire off the gun, then every time you do, it's going to affect your hearing.
Okay. So outside of that, I think, and I'm going to address my other issues during the discussion period, but my biggest concern is that I just feel like with this bill and a few others we've done in the past, if you can't handle hearing the guns, if you need a silencer to hunt, maybe you're not a good hunter and maybe you shouldn't be shooting. Like, these are just things I feel like we need to keep in the front of our minds when we're doing bills like this, just moving forward. So thank you for the question.
All right. No other questions. Thank you. If y'all want to slide over to the side, we'll get to comments. Knox Williams. Oh, that was okay. I got you. Let's see, Heather Hollett.
Okay. Thank you. I'm Heather Hallett with Georgia Majority for Gun Safety, and I'm just here to provide comment. I guess I would like to return for the public need for this legislation. There are devices that help deal with sound for people who are shooting firearms, and those devices don't interrupt public safety. The silencer would interrupt public safety. We want our law enforcement to be able to hear when weapons are fired. It kind of seems like a natural consequence. I'm a parent, so we talk a lot about natural consequences. That seems like a good natural consequence of firing a gun in the public space. I guess I would also like to echo, if the only change that is triggered by the implementation of this bill would be to reduce criminal penalties for people who are using silencers as an affront to public safety, I would hope that that would be the preeminent impact that this committee would look at. Again, you know, I would expect that when we're looking at bills, that we're thinking about the impact on the public as a whole. And while I completely understand that gunfire is loud, there are other ways to mitigate that hearing that do not pose a risk to public safety. And I would hope that public safety would be the preeminent goal of any legislation. So, and Georgia Majority represents, we are a bipartisan coalition, lots of gun owners included. So I just want to make clear that this has nothing to do with, it's about safety. So thank you so much.
No questions, thank you. Is that Michael Greenwald? How do you pronounce that? Greenwald? Greenwald. Come on down. Go ahead.
My name is Michael Greenwald. I represent Georgia Clinicians for Gun Safety. Georgia has a number of severe problems when it comes to gun violence. It's the number one cause of death in children. It's the number one cause of death in pregnant women. This is one of the states that you get a stolen gun from in other parts of this country because it's so easy to get them because they're not secured. We do not have a gun noise problem. That's not priority for Georgians. I would encourage gun owners to wear hearing protective devices for sure. We do not need to make silencers easier. We need to make everything safer for Georgians, and that's the viewpoint for Georgia Clinicians for Gun Safety. Thank you.
See no questions. Thank you for coming. All right. Let's see. I think that's all I had signed up. Anybody that I missed? All right. Gentlemen, we'll come back to you here shortly. Okay. Next up, I'll go back to Representative Scott Hilton. Chairman Hilton, come on down. House Bill 1290. Got a pretty good prosecutor with you there, too.
Thank you, sir. Much appreciated.
Thank you, Mr. Chairman, members of the committee. Honored to bring you House Bill 1290. I'll be reading from LC 481704. This bill seeks to help our seniors and disabled individuals by changing some language in two areas. Number one, you'll see on lines 12 to 15 there, we are changing coercion to without consent. The rationale there being, as we discussed in subcommittee, you are not able to coerce someone who is mentally incapacitated. Think about someone who's in a coma. You can't coerce them, but you can certainly do things to them without their consent. So that helps close that loophole there. And then the remainder of the bill closes the loophole of those who seek to abuse our senior citizens, our elderly, and those with disabilities. They will be added to the sex offender registry, which they are not currently today. I'll ask my attorney if I.
You got it.
I'm married to one, but I am not one, so I try my best.
One of the best decisions you made in life. All right. Any questions from members of the committee? Was there a loophole in the case law that we saw that judges, was it a misapplication of the law? Because I feel like sometimes we have to do a coloring book for people to understand what the statute says.
It was a gap, Mr. Chairman. There have been some instances where, and Will Johnson with the Prosecuting Attorney's Council, there have been some instances where an elderly or disabled person was, do you mean on the law itself or the sex offender registry? On the elder abuse side. There have been several cases where we had persons who were comatose in facilities, and we were not able to prosecute because you cannot coerce someone who is not awake and alert and understanding the coercion. Consent is a much easier and clearer standard because it relates to capacity.
Okay. I see no other questions. If y'all want to slide over to the side, we got.
Yep.
Let's see. Okay. See, nobody else signed up for this one. Did we miss anyone? Okay. All right. We'll come back to you here shortly, Representative Hilton, if you want to just have a seat over to the side. Let's see. Floor later, Gamble. I think he had to go to another meeting. All right. Representative Earhart. House Bill 1076. Come on down.
Thank you, Mr. Chairman. Thank you so much. It's my pleasure today to present to the committee HB 1076, a public safety bill with the purpose of protecting the lives and well-being of law enforcement officers as well as members of the public. Joining me today is Chuck Clay, a former Georgia State Senator who served 12 years on the Senate Judiciary Committee. He also served 6 years as a prosecutor for the Cobb County Solicitors and DA's offices. This bill, in a nutshell, would make it a felony to use a motor vehicle to knowingly obstruct, hinder, block, or otherwise interfere with law enforcement in the discharge of their official duties. Currently, this offense is prosecuted under a more general obstruction law found in Code 16.10.24. It's currently a misdemeanor and makes no distinction between obstructing with a body or obstructing with a 3,000-pound motor vehicle. The reason for carving out obstruction with a motor vehicle from the general obstruction code is because of the dramatically enhanced risk of danger and personal injury associated with using a 4,000-pound vehicle to obstruct an active police operation. If this vehicle at the same time is also driven by someone with the intent to obstruct or impede that operation, the outcome could be, and sometimes is, dire for both our law enforcement officers and the people engaging in the obstruction. It is dangerous conduct and should be taken seriously. Georgia is not alone in this concern. From 2020 to 2025, there has been a 230% increase in state-level bills filed to combat vehicle-related crime like this one. Why is that? Let's be very clear about the danger. Over the past 20 years, motor vehicle-related incidents, on average, have been either the number 1 or number 2 cause of death and injury to law enforcement officers, second only to gunfire. From 2023 to 2024, deaths to on-duty law enforcement officers as the result of motor vehicle incidents rose by 48%. The danger is real. A motor vehicle in the hands of an ill-intentioned person is a lethal weapon. The goal of HB 1076 is to provide an enhanced deterrent to obstruction with a motor vehicle by increasing the penalty from a misdemeanor to a felony. It is likely that in some situations, many individuals who engage in obstruction don't anticipate that their actions could actually end in injury or death to themselves or law enforcement officers. We want to deter this crime before injury or death occurs. With motor vehicles, a non-dangerous situation can escalate in a matter of seconds to a violent or deadly scenario. As with all criminal offenses of this nature, intent, of course, will need to be proven and will be a prerequisite for a conviction of this crime. It is worth stating that both the Chiefs of Police and the Sheriff's Association support this bill. The Prosecuting Attorney's Council does not oppose the bill. Ladies and gentlemen, that is it in a nutshell. I'm certainly happy to see if my partner and friend here, Chuck Clay, has any comments he'd like to make.
Very briefly, Mr. Chairman, you can tell I obviously checked to see what you'd be wearing today, so I want to thank you for giving me the heads up. And I will be brief. The other thing that I would like to point out, back in my day, you had an obstruction, which is a misdemeanor offense, and it was normally at a scene where maybe it was a family or a friend, and there's alcohol, and there's agitation, anger, and the laws were adequate. We did not anticipate, and we also knew what an aggravated assault on a police officer was, and whether it was hitting somebody with a car, trying to run them down, shoot at them, threaten you, those type of direct threats that already a law is in place. We did not anticipate nor did law enforcement at a time and place. When you look at instances like has occurred in street racing in Atlanta, when you had that small tragedy at the Wendy's that was burned down, you had people with the intent of not assaulting police officers, but the intent with their vehicles to very consciously prevent. In street racing, to prevent law enforcement from having access to the perpetrators. And a scene like occurred at Wendy's, you had folks blocking roads, threatening people, and in fact preventing law enforcement and creating an incredibly dangerous scenario for all involved. So this is simply trying to take the facts that we see as today of individuals who are not responding to an emotional, instantaneous instant of bad judgment for which the misdemeanor offense applies. But these are people who are making very conscious decisions to use their vehicles to obstruct, directly obstruct, but while obstructing, putting people's lives in danger and thwarting the process and the investigation by officers on scenes that can change dramatically. Time is instantaneous, and those people who do this ought to be subject to the kind of fine and penalty that is presented in this bill. And I'll hush up other than saying it's always an honor and privilege. If I can answer any questions, certainly the author of the bill, be happy to do so. But again, thank you for your time.
Okay, you have one, looks like Party Jackson again, Representative Panich.
Thank you. I have a question. And you mentioned, or your witness mentioned, the Wendy's incident. Are you saying that no one was charged in that case because there was a gap in the law?
There are people charged in the case, people charged in very serious offenses, but there are those that may be involved in peripheral conduct that, if not an aggravated assault, would have fallen within the parameter of a misdemeanor offense. So I do not for 1 minute intimate that people cannot be charged with conducting specific crimes, whether it be aggravated assault, whether it be assault on a civilian, whether it be a misdemeanor obstruction. But there are those who consciously involve themselves with vehicles in obstructing law enforcement that creates enhanced danger, thwarts the process of law enforcement and investigation. But I by no means want to intimate that I think there are no other charges that can be applicable in a scenario.
Okay, may I have a follow-up? So is the purpose of this bill to raise this from a misdemeanor to a felony if somebody was obstructing with what you believe to be, or what you believe that they are obstructing with your vehicle?
That is the purpose of the bill.
Okay.
It absolutely is. And if I may follow up, Representative Panich, I know that you made a remark, I believe, in subcommittee about questioning why we would have a felony for a nonviolent offense. And I would like to just kind of maybe touch on that just very briefly, that this offense and offenses like it are classified as felonies because they involve a great risk and potential danger. And legislatures often treat weapons-related conduct as inherently dangerous due to the serious possibility of, well, not only death and injury, but just rapid escalation of an already precarious situation.
Thank you.
Thank you.
Number 5. Representative Hall.
Thank you, Mr. Chair. Madam Representative, I was under so much has been spoken about obstruction. I was wondering, were you familiar with Title 16, 16-10-50, hindering apprehension, that is currently on the books? Were you actually aware of that, and how does this bill actually replace that?
Right, and I'm sorry if I'm not familiar with that particular part of code. I know that currently we have obstruction laws on the books in 16.10.25.
I can provide
right,
it.
yeah, and thank you for that, and thank you for the reminder, Mr. Clay. That this bill, remember, that is not addressing specific danger as a result of utilizing a motor vehicle to obstruct, and that's kind of the purpose of this. We're in a better mode of explanation. We view it very different from an individual. Let's say someone's approaching a police officer looking to obstruct, and they're doing so by yelling at the police officer, or they're waving their arms. We're viewing that very different than actually injecting a large automobile, a heavy piece of equipment into the center of a active police operation. We view those as very different, and hence the need for this particular enhanced penalty.
Thank you. Small follow-up, sir, if that's okay. I'm noticing, particularly with looking at the culpability of the person, that the intent is only based around their knowing, or rather should have known. And I was actually curious as to, are you familiar with cognitive dissonance with respect to the stress of a situation? And I'm just saying it. I know personally, having to remove children from a burning car, and the driver themselves actually being excited because of the anxiety, the pressures around them, the smoke and the cause of the fire, that in situations where persons may be in the middle of a law enforcement officer arriving to the scene, and because of the immensity of the circumstances, they may actually freeze. That is a common human response. Do you see that perhaps by this law going through, because it doesn't actually raise it to the level, the intentionality is just at a possibly knowing that you actually could not necessarily get criminals arrested, but maybe older persons, our seniors, persons who themselves never find themselves in a position to actually respond in emergent circumstances?
Well, I think if you're talking about seniors or people that are in some way inhibited or encumbered from being able to understand intent for whatever reason, the stress of a situation,
any person,
then that clearly would not reach that bar of intentionality that is set. And there are so many different ways. It's not the responsibility of this body or the legislature in general to set forth the guidelines by which a prosecutor would determine intent, but certainly the intentionality is a very, very important piece of this legislation. That's why it's in the bill. I'm sorry, Mr. Clay, if you'd like to say something. I would just close that by saying, there are just so many different ways to prove intent, whether it be the actions before, during, and after the obstruction, the failure of an individual to follow or comply lawful instructions given by a police officer. I mean, these days we have body camera dash cams. We have video footage from bystanders. I think that benchmark for proving that intentionality is we are, under most circumstances, well equipped to determine that, or law enforcement as well, and prosecutors are well equipped to determine that. I would argue that any scenarios that you just described, and I think you mentioned elderly people or someone who just in the stretch of the situation freeze, I would believe that would be outside the bounds of that intentionality. They can't control that.
And so therefore the laws that are on the books currently address that, which in fact there's no need for an upgrade if that is something that can be decided in court.
There's a need for an upgrade because of the danger associated with this particular type of behavior. Sometimes people will say, and I've heard the question asked today, what is the need for this law? Why is there a need to carve out specifically obstruction with a motor vehicle? And I would argue there are many reasons, one of them being a 48% increase in law enforcement officer deaths as a result of motor vehicle-related incidents.
Just might also add, you all know this, very first thing you learn in law school is mens rea, and they pound it into intent, either ad nauseum or ad infinitum. As you well know, you can impute intent from circumstances. You can also rebut intent by circumstances. The fact that there is an ability to charge doesn't mean charges will be made. There are other offenses, if you said, from hindering to misdemeanor obstruction to an aggravated assault on a police officer. Likewise, as you well know, and maybe it's too much, maybe it's too little, but during the process, the justice system itself, both the district attorney, counsel, a defendant will have, should have, and will have ample opportunity. There's not a perfect answer, but obviously you well know charges can be raised, charges can be lowered, charges can be negotiated, and quite honestly, I think having an array that you can deal with not only helps law enforcement, but also gives a greater leeway, if you will, to look at lesser included if the circumstances impute or if the circumstances, in essence, rebut intent altogether.
Representative, thank you for your question.
Number 3, Representative Kendrick.
Yes, thank you. Sorry, I am tardy, and I'm sorry if you already answered this. 2 questions. So lines 18 through 20, just so I understand this. So we're raising the penalty to a felony, even though there's no contact and no death that occurs because of the vehicle. Is there anywhere else in the code section where it has a similar punishment, but there is no contact and no death that is associated?
I can think of quite a few. There are quite a number of felonies that are considered nonviolent. I mean, one that comes to mind initially, of course, there is damage to property, would be a bill that the House passed, is in law now, and that is enhanced penalties for setting a police car on fire. It doesn't have to be any harm to physical harm to people in that situation. That's a property damage, and we enhance that to a penalty. Mr.
I would
Clay,
also
maybe.
add, if I were to pick up a gun and point it at you, I would never do that. That is an aggravated assault in and of itself.
Okay. And my second question is, we keep mentioning the word intent, and I just want to make sure that I'm reading line 15, because I've seen it in code where it has to be knowingly and intentionally, but we kept in the last discussion saying the word intent, and to me, intent and knowingly are 2 different words with 2 different meanings. So I want to make sure that we are, I mean, I have problems with the bill, but I at least want the wording to be correct. So is knowingly on line 15, should it be knowingly and intentionally as to be
Right.
consistent with the code?
Based on my conversations with legislative counsel, I believe that they felt that by including the term knowingly means that the individual has an understanding of the action that he's committing and the possible results of that action. So therefore, if they are aware, if they know that what they are doing is impeding that law enforcement operation, and they continue to act on that, as stated in the bill, that is implying intent. I don't know if Mr. Clay has a different take on that, but that is how it was explained to me, is that those terms are intentional to the effect that you described.
I'm not sure.
Number 6.
Thank you to the chair. So I guess I'll discuss the other aspect of this during the discussion about excessive charges, stacking. Just a little concerned about that, because I feel like we can still write for this crime under 1610 24B as a felony, just having to explain what it is when you write your police report or what have you. But my other question is related to, you mentioned some percentages related to motor vehicle related incidents. And I was curious about how many of those motor vehicle related incidents are related to an officer being harmed by, an assailant in a vehicle, because the percentages are already high because law enforcement is already hurt or killed because they occupy a vehicle when they're actually driving it for their
Understood.
duties. Do
Understood.
you have the numbers related to
No,
it?
I don't have them broken down by that, but
So the ones that you're reading currently.
Yes, that increase, that encompasses all motor vehicle related incidents. So all of those types of things have increased within that 48%. I do not have the exact number or the amount that it has increased by, but we know that we know there has been a dramatic increase as relates to deaths of law enforcement in any and all motor vehicle related incidents, and it would include this as well.
Well, I think we want to be careful for the purpose of this committee, like if we're going to be given numbers and we want to, assess your bill appropriately, to make sure the numbers are related directly to what we're outlining here and not encompassing the high number of officer injuries or
We
related
know
to when they're
also
driving.
when we talk about the incidence of a motor vehicle being a deadly weapon, those numbers speak to the reality of the lethality of a motor vehicle. So I think it kind of lends itself to the argument that it's obstruction. What is the difference between obstructing one with the body or obstructing with a police vehicle, with a motor vehicle? The concept being there is that motor vehicles, however they are used, are a risk to the lives of law enforcement officers if they are in the hands of people who have ill intentions.
Gotcha. Thank you.
Number 7.
Thank you, Mr. Chair. Do we know of another crime that carries $100,000 criminal penalty?
There's a current code section that if a felony does not provide within the particular statute for a fine, that it would be a $100,000 fine. So I can find that and send it to the
I
general
appreciate
lady.
that. Thank you.
And of course, that doesn't mean they have to impose that. That's a fine out there. That various ways to deal with, but probably the least concern on here, if that is an angst and the committee would like to address a matter.
I was just curious. So Mr. Chair, it's my question. I have one more quick question. I'm trying to figure out how a stationary car can be dangerous.
Based on my conversations with law enforcement, I've had an opportunity to speak to quite a few. The dangers associated with a parked vehicle are actually numerous. Driving or a parked vehicle with the express purpose of obstructing a police operation, we know that is conduct. What are some of the concerns that could be related? For one thing, the parked vehicle has to get there. So oftentimes, even after it's stationary and parked, it has been driven into a police operation and left there. Some of the things that law enforcement brought up to me that are concerns with parked vehicles and how that can impede and put officers in more danger. Number one, it prevents emergency response. So given the situation where it is, if it's parked on a road, you inhibit the ability of other police emergency vehicles or ambulances, anything of that nature, to be able to access that location in and surrounding that police operation. It has a tendency to escalate situations. It intrudes on quite frankly on the attention and the ability of that police officer to focus on the operation at hand. This is one more thing that he has to deal with. Oftentimes, the parked vehicle is just one step in an increasingly elevated situation. Either these vehicles are sometimes driven first to impede and then they're parked, or they're parked first and then they're driven to impede. This is simply one more step in an escalation of a volatile situation. I would say one of the things that in my mind that is most concerning would be the fact that you are preventing emergency vehicles or anyone from accessing that law enforcement operation.
Okay. No other question, or there was one over here. Representative Byrd, do you wave? Or Chairman Burchett, or Whip Burchett?
Thank you, Mr. Chairman. I was just going to ask the author, isn't it true that a parked vehicle could obstruct people from entering or exiting a crime scene? Is that?
That is correct.
Okay, thank you.
In other words, act as a barricade?
Yes, very much so.
All right. Thank you. I see no other questions. Did Pat wish to comment on this? Okay. Y'all don't have a position for or against it? Okay. Correct. All right. Thank you. All right. Next up, thank you, Secretary Hart. If you want to slide over to the left there. Believe I have only one signed up, and that would be Gacknell Mason.
Thank you, Chairman. Maisie Lynn Girton. I'm the Executive Director at the Georgia Association of Criminal Defense Lawyers. We spoke to this bill in subcommittee, so I don't want to belabor the conversation. I'll just review quickly our position, and also one thing that's come up today. The thing that came up today that I did not mention the other day because I didn't appreciate it until this moment, but if you look at line 20, the punishment scheme that's laid out here is a fine and imprisonment of 1 to 5 years. I'll just say very practically that when someone is spending time in prison, it's really difficult to pay off a fine. So allowing the court to assess the situation and the financial situation of the person in front of them by making that and in line 20 and or and then adding or both to the end, like we see in a number of our criminal code sections, would just be a much more practical response here, allowing for whatever fine is necessary, but not setting people up for failure simply because they're having to go to prison and unable to pay that fine. It is our position that we understand that blocking a roadway does cause problems, and that right now you have a misdemeanor level punishment, but then you also have an aggravated assault level punishment when someone does cause an aggravated assault to occur where the victim is a police officer. And you'll know that you all raise the bottom penalty on that. If the person is a law enforcement officer in the course of their duties, the person that is convicted of committing an ag assault against them will receive a sentence of a minimum of 5 years and a maximum of 20 years, which would cover things like a moving vehicle coming at an officer. There's no question but that a moving vehicle is a weapon. However, we understand blocking a roadway is more serious, and as I said in subcommittee, we would recommend that the committee consider a high and aggravated misdemeanor in that case, which does raise the financial penalty from what it is now at $1,000 maximum to $5,000. And it takes away a majority of the good time that person would get in jail if they were to get credit for time. On a misdemeanor, they might be able to serve half of their time, but on a high and aggravated, they can only get 4 days per month of good time. It would give a middle ground between the garden variety obstruction that we have today, that is the lowest level misdemeanor, and the ag assault that you've got when you really do have harm to the officer. And that's all I would have to offer. If you have any questions, I would stand for those.
See no questions.
Thank you.
All right, and I didn't forget you, Zareta Reyes Garcia. Okay, my apologies. Brandy Blue with the ACLU. Sorry, Brandy.
I was gonna say hello. All right. Good afternoon, Chairman and members of the committee. My name's Brandy Blue. I'm a legislative fellow with the ACLU of Georgia, and I'm here today to oppose 1076. Basically, just going to quickly echo some of the comments that have already been made by the representatives here. There's two main issues we have with this bill. Under Code Section 161024A, as has been referenced, general obstruction of a law enforcement officer is punished at the misdemeanor level, and subsection B of the same code increases the penalty to a felony if violence is used against law enforcement in the course of the obstruction. If someone uses a moving vehicle to obstruct law enforcement activities, that could easily be considered violence, and the person could be charged under subsection B of the code. And if for some reason that code section did not apply, Section 16(5)(c)(21) does. It establishes a felony punishable by 1 to 20 years in prison for aggravated assault with, quote, any object, device, or instrument which, when used offensively against a person, is likely to or actually does result in serious bodily injury. So in that way, the Georgia Code already has this covered. Additionally, as some have mentioned, we take umbrage with the language about stationary vehicles. If the intention is to protect law enforcement from violence, from someone using a car as a dangerous tool of obstruction, a moving vehicle can easily be seen as dangerous, but it's difficult to imagine the same threat from a stationary vehicle. With that in mind, we asked the sponsor in this committee for two considerations. First, since the code already addresses violent obstruction, the only language between the code and this bill is a fine. Simply add language to subsection B of 161024, allowing for a fine that is comparable to other felony charges. Or secondly, if the sponsor still wants to put this bill forward, remove the word stationary from line 15 in the original LC. Thank you, and I'm happy to take any questions.
No questions, thank you. Believe that's all I had signed up to testify unless somebody straggled in and we didn't get you on the list. All right, what says the committee? Move to pass. Do I have a second? Second. All those in favor of the passage of House Bill 1076 LC 630048 say aye. Aye. All those opposed? No. Okay, ayes have it. Okay, thank you. You're on the rules. Get me the form and I'll sign it. All right, I'm going to go back to House Bill 1324. I believe we had discussion already. Representative Ridley, if you want to come on back to the seat. All right. Now would be the time for discussion. Number 6.
Thank you to the chair. So I think a few concerns I have are related to law enforcement who's expressed some issues with this. They've used gunshots to be able to go after active shooters. Even when I've trained, I've done the active shooter training. When I was in law enforcement, we used the shooting to help guide us through a building and make it where we can, get the assailant. And we watched countless videos across this nation where officers have been able to neutralize the threat just simply because they were able to hear. Kids have been able to get out of the schools because they can hear and know to go the other way. There's so many ways that preventing silencers can really help by making it where we don't touch the issue of silencers, make it where people can be safe, children can be safe, even when it comes to schools. And even to take a step further, the regular 911 calls. Even when I responded to 911 calls in the past, just simply if I can hear the gunshots, I know where to go. It just makes life easier on the road, and that has been expressed to me through law enforcement who's communicated with me on this subject. And also to just take it a step further. In recent years, when the current president, Trump, was an assassination attempt was made, after the first shot, 4 seconds later, the Butler County Emergency Service Unit was able to get shots off to that shooter to make it where he couldn't shoot anymore. 12 seconds later, that shooter was shot and killed by a counter sniper team from the United States Secret Service and prevented them from killing the president and prevented them from killing other people. So I just submit to you, I think this doesn't have to be a partisan issue. Not moving this bill forward today will really aid in making sure our law enforcement can be safe, our children can be safe, and the current president can be safe.
Glad to hear there's so many Trump supporters over there on the other side of the aisle. Number 7.
Thank you, Mr. Chair. I won't reiterate all of that from the law enforcement perspective, but also in 2019, the Virginia Beach shooting, a silencer was used, which led to more deaths as the shots weren't initially recognized. And since y'all have admitted here on the record that this is primarily a preemption bill, presuming that federal law will change and that currently under federal law you can register your silencers now to use hunting, the only people benefiting from this law are criminals who will no longer have an enhanced penalty if they use a silencer in the state of Georgia to commit a crime. And so I am opposed to a bill that only helps criminals and is going to be to the detriment of law enforcement and our public. Thank you.
Number 5, Representative Holly.
Thank you, Mr. Chair. I do echo the considerations of my colleague seated to my right, that in over 150 cities throughout the country, ShotSpotter, which is actually currently known as Sound Thinking, has been actively coordinating with police departments to actually to find out where has been the source of a shooting. And while I don't think, I think it's certainly arguable as to whether or not we, might appreciate, certain person in the Oval Office. I think just for the general safety of making sure that, our leaders are not gunned down without law enforcement being able to track exactly where those shots come from. And with the shot spotter system having a high accuracy, a rating of over 97% when it's used in the solving of crimes, that is actually effective by taking that out of the hands of and making it very harmful. I think you also additionally make it very tough for law enforcement to actually go about finding the originations of these shootings. That's all.
Number 12, Representative Panich.
And questions, right?
This is discussion.
Oh, okay. I came in a little late, so I missed some of the testimony, but I don't understand, maybe someone here can help me, how you would handicap law enforcement, or why you would handicap law enforcement by not being able to find the source of the shots in favor of just helping people who want to hunt not have to wear earmuffs. I mean, I'm not understanding I don't understand the benefit that compared to the risk, which harms everybody, anybody who hears a gunshot, to know where it is or what area to avoid. And I'm just having a hard time understanding how you made that balance come out in the favor of a hunter who doesn't want to wear an earmuff. Thank you.
Number 14, Whipper-Chip.
Thank you, Mr. Chairman. So as someone that has heard a silencer, I don't know how many members of this committee has heard a silencer. It is not like the movies. You don't hear a it is a greatly reduced percussion, but it is very, very audible to the ear, particularly with a large caliber rifle. You're going to hear a significant sound, whether you're outside or inside. This doesn't silence guns entirely. I just wanted to make sure the committee knows that. There is no silencer out there, and I have a close friend that is in that business that will make it sound like the movies. The gun is going to be audible from a long way away, but it does reduce this sound to the shooter. Thank you, Mr. Chairman.
The gentleman knows what he speaks on that. Not like you'd see on GoldenEye on the old Nintendo 64 is what I think he's trying to say here. All right. Representative Ridley, I'll give you the last word.
Okay, thank you. As Chairman Burchett over there said, this does not silence it. It's still loud. It's just not as loud. It's just a suppressed sound. And as much as I've heard people complain about fireworks, if you've got somebody next door that's shooting, you'll wish they had one of these on there. And as far as the criminal side of it, these things cost more than the guns do. Silencer costs more than a gun does, a real one. Now, you can buy one online right now that you can screw a oil filter on. I mean, off just a redneck version of it, I guess is what you would call it, that'll do the same thing. That's something that's illegal. But this is actual ones that you have to have stamped. You have to have a federal license to have them. It's linked to you. So it's just a whole lot different here in the city, and I guess it is out in the country where everybody's shooting all the time. So that's the crux of the bill. I mean, it just quietens everything down.
Thank you. I'll entertain a motion.
Do pass.
Her light was on first. All right. Motion do pass. Second. Is there a second? Second. Motion do pass and second. See no amendments. All those in favor of the passage of House Bill 1324 LC 394953 say aye. Aye. All those opposed, same sign. No. Ayes have it. You're on the rules. We can do a hand count, sure. All right. All those opposed, raise your hand. All right. All right. You can put your hand down. All those in favor. Chair votes aye. You're on the rules. All right. I'm going to recall Representative Taylor's bill, House Bill 421. All right, go ahead.
Okay, I would ask for your favorable consideration for House Bill 421, LC 481780S. And this just adds to our criminal code that if anyone travels from another state for the purposes of child molestation or indecent acts, they would have a criminal penalty.
Okay.
Move to pass.
Got a motion to pass. Second. All those in favor of the passage of House Bill 421, substitute LC 481780S, say aye. Aye. All those opposed, same sign. Congratulations, you're on the rules finally. Just bring her, Chairwoman, if you'll go through the lobby there and come around, we'll get you signed.
Thank you.
Yes, ma'am. All right, next up, I'm going to call back Representative Hilton, House Bill 1290. I'll give you the last word on this.
Need a good bipartisan palate cleanser right here, you know. Just let it swirl around. This bill, House Bill 1290, targets sexual exploitation of an elder person, disabled adult, or a resident of a long-term care facility. In my initial presentation, I did leave out that we are changing from it used to, it removes the requirement that a person must be a caregiver or authority position, as, you know, really anybody can sexually exploit these people, whether it's a neighbor, a family member, or someone else. So we don't want to prevent the prosecution just because of that there. And so I will pause for any discussion or a motion.
All right, move a second, do pass. Discussion on this, number 13. Is that you, Representative Bird? Go ahead. All right, discussion on it.
Thank you, Mr. Chairman. I just want to be clear about this, Representative. So if there is someone that is considered one of those persons that happens to be in a hospital but not a residential home, as you stated, long-term care, would this also apply to them if they had been sexually abused?
I believe it just applies to long-term care facility.
No, it applies across the board.
Okay.
It's an elder person, disabled adult, or someone in a long-term care facility.
Okay, so if I am just a normal everyday person and I'm in the hospital and I happen to have something like that happen to me in the hospital, that I would not be covered under this bill?
You would be covered.
I would be?
Yes.
Okay.
As long as you were in those 3 protected classes.
Elder, disabled.
Well, I guess I consider myself elder, but.
Not to me, Representative.
No.
Spring chicken.
Yeah, right. And a follow-up question, please, Mr. Chairman. And for compliance purposes, how is this going to be monitored and enforced? I mean, are we going to have cameras, or are there cameras already in all these places so that if someone comes forward and says, this happened to me, I was raped, I was abused sexually, how will we know that? Please.
In some of the cases, we have eyewitnesses. There have been some where CNA caught someone in the act. There's no requirement the facilities have cameras, but there are a lot of folks that put granny cams, as they call them, in facilities and places. If it's in the home, it could be any number of witnesses or home security systems. It would be case by case specific how we proved it.
Thank you.
Okay, no other discussion. I've got a move and a second. All those in favor of the passage of House Bill 1290, LC 481704, say aye. Aye. All those opposed, same sign. Congratulations, you're on the rules. If you want to bring the form around, I'll sign it. All right, next up, I'm going to call House Bill 626, Representative Karen Lupton. Okay. Inga, are you ready on House Bill 1390? Come on down. And we're ready when you are.
Thank you, Mr. Chairman. Thank you to the entirety of the committee. I'm Representative Inga Willis, and I present House Bill 1390. 1390 strengthens Georgia's reckless stunt driving law by addressing offenders in a meaningful way. The differentiator between this and the other progressive steps that we've taken as a state to address drag racing and stunt driving is that this focuses on the vehicle as the vessel and would allow it to be considered as contraband. I have with me today Lieutenant Carlos Maldonado from Atlanta Police Department, who specializes in auto crimes enforcement and serves as its commander. As many of you know, we have a serious problem with drag racing and stunt driving in Atlanta, but it also impacts other areas. This is a subculture. It's a meetup culture. It's very hard to track. It has caused injury. It has caused multiple incidents, but this is not just an Atlanta problem. This is a Georgia problem. So targeting the vehicle itself, known as the vessel, will further help combat this issue. And one of the other things that makes this have a differentiator is this bill includes a hardship provision. If the vehicle is the family's only vehicle, then the court may transfer title to another licensed family member in the home if it would create undue hardship and it's the primary vehicle used to get to work. This bill is about deterrence. The changes in the code section 40-6-390.1. In line 9, you'll see the new language, which shifts to any motor vehicle operated by a person who is arrested and charged with a violation of this code section is declared to be contraband and subject to forfeiture in accordance with procedures set forth in Chapter 16 of Title IX. I'll pause there, and I also have Lieutenant Carlos Maldonado with me to answer any specific questions and to speak to the hurdle that this presents to the Atlanta Police Department, who seeks to combat this crime. Thank you.
See no questions from members of the committee. Oh, there's one. Whit Burchett.
Thank you, Mr. Chairman. Representative, is it, so we're just removing the provision that requires there has to be a previous violation of the code section? So it is the first one, is that right?
Yes, sir.
Okay.
I believe that adding more deterrence to the behavior, we already have penalties in place if you're a second-time offender or third-time offender, but it focuses primarily on the behavior of participation and not on the vehicle itself as the vessel. You can't drag race on foot. If you can, I've never seen it, or they should sign up for track and field. But specifically with the vehicle, these vehicles take great investment. These are not the vehicles that we drive into the Capitol every day. There are thousands and thousands of dollars put into these vehicles to make them, you know, supersonic in the ways that require you to be a great drag racer. So what this does, in answer to your question, is yes, it eliminates that language, but it also puts a focus on the vehicle as the vessel.
Well, thank you for the bill. I think it's a great bill. I was going to ask the Lieutenant.
Lieutenant Maldonado.
Sorry, Lieutenant Maldonado. So have you seen some of these Fast and the Furious vehicles that we're talking about?
I have. Unfortunately, every time we have a big event weekend in the city, the street racers love to come out and put on a show, so it's very common.
Very good. So, good bill. Appreciate you bringing it.
Thank you.
Number 6.
At the appropriate time, I was going to make a motion.
Okay. I want to make sure we don't have anybody signed up on here first. But I'll come back to your motion here shortly. Representative Willis, thank you for coming up here on such short notice.
Thank you.
Carl, okay, I got you, Lieutenant. Thank you for that. I know where I'm not coming to drag at. Let's see, Blake Feldman, Southern Center. Come on down, Blake. If one of y'all want to scoot over and let him come by.
Good afternoon. I'm Blake Feldman, Senior Policy Counsel at the Southern Center for Human Rights. We oppose this bill, and to talk a little bit why, So, this isn't the first time that this bill has been changed in some way. So, in 2021, the city of Atlanta asked for this bill and created this offense. When they created it, because there was serious concern about asset forfeiture being quote unquote policing for profit, and there being mistrust in the community with law enforcement. It was one of the first bipartisan issues that I experienced in 2015 working with the ACLU in Mississippi. The first thing I worked on, all of a sudden, Reason, Institute for Justice, Cato, everybody was talking about asset forfeiture reform. So in 2021, through House Bill 534, they created this offense. Asset forfeiture would only happen when you were arrested for this offense if you were deemed a habitual offender. So after several convictions. And then in 2024, they came back, and those graduated penalties that we've talked about, we upped those penalties, or not, the General Assembly upped those penalties, and also removed that requirement that when you're arrested, this guardrail before shifting the burden of proof from the government to the legally innocent person who's been arrested. It was, you had to have been an habitual offender and have had a suspended license. In 2024, we reduced it to you just had to have one prior conviction. Today, we're asking you to change the statute again, and it would be changing it to where there's no guardrail, and it's just pure civil asset forfeiture. Just you've been arrested, you've been accused of something, we're taking your property unless you can prove otherwise, and that burden shift. We think for all of the reasons why it was bipartisan moves across the country to move away from asset forfeiture as a practice. We just don't want to see that being retreated against, which is what this bill would do. And that's all I got.
All right, number 5, Representative Holly.
Thank you, Mr. Chairman. Thank you, sir, for providing your expertise. I was curious, is that would you find it to be more defensible if is per a conviction that the asset would actually remove from out the hands of the person who was accused to a family member if it was a primary vehicle for family? You said you find in Section 2. So, for instance, all right, let me make it clearer. If the person was charged and it was actually a family vehicle, would you find it that this particular law would have made better because asset forfeiture is such a touchy issue, that it would have been better that if they're actually convicted, that the asset move out of their hands? I'm trying to figure out.
Yes.
Yes, okay.
Number 14, Whitmer Chip.
Thank you, Mr. Chairman. I missed your name. Will you give it to me one more?
Sorry, Blake Feldman.
Blake, Mr. Feldman, has those, you went through the progression of where we have strengthened the penalties for this street racing. My question to you is, has it worked? Have they stopped?
I think that if tackling this issue through this code section was the correct way to address this problem, then we wouldn't be here.
Right. So it hasn't worked. So making it a stiffer penalty, at least in my my thinking is, if I'm going to race and they're going to take my car, I may not race. Does that comport with your rationale or no?
I mean, I think that I think if that were the case, then lots of people would be having this seized upon that arrest after a prior conviction.
So before, if I was, an eager 16, 17, 18, 19-year-old and wanted to race, I knew after talking to my fellow racers that you can't drive. You've been convicted. You've been charged. But Representative Byrd hasn't been charged. Not that you would be racing, but I mean, you know, someone that hasn't been charged could race. My only point is that it seems like this is a problem, certainly not a problem down in South Georgia, but it is a problem that I've heard all my colleagues from Atlanta, Fulton area are dealing with. They're trying to handle it, and I share some of the concerns about civil asset forfeiture, but we're trying to cut this activity out. You have a suggestion how to do it?
I think that, I mean, generally even enhancing penalties, the science showing that the likelihood of getting caught, the likelihood of getting in trouble versus the extent of the punishment is usually has the greater deterrent effect. I just think that I think that we are most concerned, or the reason why we shared concerns with people who have very divergent politics on lots of different issues is just that we're not talking about increasing a punishment generally. We're talking about completely shifting the burden of proof.
Yeah, I think that's kind of like where my mind's at. Is it seems like we can put folks in jail forever, and we can, you know, fine the crap out of them, and they still keep doing it. I mean, my truck's been broken into twice in Atlanta. In broad daylight at 11 a.m. Right there on Peachtree, and we have increased the penalties. Now if we start taking their stuff, maybe they'll stop doing it. They can stop taking our stuff.
I think taking people's stuff after proving beyond a reasonable doubt, we would have much less concern than taking it because you've been accused.
That's fair. That's fair. Appreciate your testimony.
Sure. Thank you.
Okay, let's see, number 6.
Thank you to the chair. Good to see you. So just a quick question, and I won't belabor the point after the whip has outlined some of the things I was going to question about, but in your opinion, do you view this bill as one where these people can't get their items back after a case has been disposed of?
I think I'm not sure when this bill was added to the agenda, so I haven't had as much time to fully prepare. But in my experience, I think that property can be disposed of that's been seized before the termination of a case. So if it takes you a long time to go to trial, it could be that that car's gone.
Gotcha. Okay, that's all I got for now.
Number 13.
Thank you, Mr. Chairman. Thank you for this bill. Just curious, I'm trying to figure out, so if someone is drag racing and they've had prior offenses, but they use their car to get to work, or a family member does, the car would not be taken and put in a stockyard somewhere until the case is finished. Could you explain?
The hardship clause?
Yes.
Yes, I would. And Mr. Chair, if I may bring back up Lieutenant Maldonado, if that's okay. Thank you. Thank you for the question, Rep. Byrd. The hardship clause means that if it's a financial hardship to the family that outweighs the benefit from the state, right, and that family needs, another family member, needs that vehicle to get to work. That is where this comes into place. Not back to the offender, but to an additional family member who may use this car to get to work. That's why that's put in. And the lieutenant could speak to it more specifically from a law enforcement perspective.
Sure. And to that point, for clarification, the way it's already codified into law is that it can be used one time. So if that person was given the opportunity, and the family was given the opportunity to use that vehicle, and then they're caught in that vehicle again doing the same type of act, that opportunity's already been used. They cannot use it a second time. And that's already written into the code section.
Okay, so if, follow-up question, if I am the driver of this particular car, and I have already gone through the process before, I've been picked up and charged, but I need my car to get me to my job, that is that would be a hardship for me, would it not? Or just strictly for other family members that may use that car?
Sure. The way it's written now is that the vehicle, if it's the family's only source of transportation and the loss of that vehicle would be that significant hardship for the family, it would not apply.
Just to be clear, just to be clear.
Can't hear you.
That if I were the driver and I were making the one who is helping the family put food on the table, and I was the one that was caught using the car, and I need that as a purpose to get to my position, the car would still be in my position and in my possession. Is that correct?
Correct. That ultimately would fall. It would be on the person to articulate that, but that would be the judge's discretion at the end of the day.
Very good. Thank you.
Okay, I think I skipped over Maisie Lynn with Gactyl. I think you were signed up on this one.
And I'd like to bring Andrew
Yeah.
with me.
Andrew McCall, Lawyer of the Week for Gactyl. Good to have you with us. Just tell us where you're from.
Thank you for having me from Decatur.
Okay, good deal. Whichever one. If y'all want to slide over.
I'll slide over.
Again, I'm Maisie Lynn Gerton, Executive Director at Gactyl. This is Andrew Hall. He's a practitioner here in the metro Atlanta area who also has a background as a prosecutor, so comes with a lot of experience on both sides of the courtroom for you to draw from today. I would like to kind of follow up on some of the conversations that have happened so far. One is, Representative Byrd, you don't have to pass this bill to have the hardship. It's already in the law. You'll see it there at lines 13 through 19. It's current law. And to your point, it is not the person who's convicted who would have a right to keep that car. In fact, the title has to be transferred to such other family member who is a duly licensed operator, et cetera, et cetera. So it does not contemplate keeping that title with the person who's causing the harm. It contemplates keeping the title with the family, so that the family isn't suffering a hardship because of the behavior of one person in that family. And that's current law today. That's happening right now. But here's the trouble, Whip Burchett, I would just love to talk a little bit more about the timelines here, because in fairness to my colleague from the Southern Center, I don't think we have a sense of how well things are going yet, because cases don't get to court this quickly. You know, the most recent effective date of a change to this code section is 2024. We're not even 2 years in, and this is a felony. Cases they don't even move that quickly in state court. So I don't think we know yet what the outcome of the changes that were made most recently are. But what I know is that if you dial back this recidivism piece here, you are definitely taking the property of someone who's simply accused of a crime. And that is our strongest concern. Would be our request that you give this law a chance to work. Give it a chance to do what you were hoping it would do when you passed it, rather than continuing to make it more punitive by taking things before someone's convicted as a pre-adjudication punishment. And just consider waiting a bit before you move forward on a more regressive policy measure.
You want to say anything further?
I'll weigh in briefly if I may. Thank you for hearing from me. A few different comments. So I do practice in Fulton County quite a lot. It varies the timeline, but I would say rough ballpark, 1 to 3 years to get a felony through Fulton County. So to the comment made by my colleague here about we don't have the data yet as to whether the Assembly's latest change to this law has been effective. We just don't know. It very well could be effective, or very well could not be effective. There's an absence of data, and that's because of the timeline. So what you're hearing, I respectfully submit with all, I've actually run across Lieutenant Maldonado before. I like him a lot. Great law enforcement officer, but he's dealing with anecdotal information, real world right now. We don't know yet whether the deterrent effect of this law has come into effect yet, because we just haven't gotten these cases far enough through the judicial system. Another thing I would point out is that the way the law is currently written is it has to do with the perpetrator's operation of the vehicle. It's not that the perpetrator has to own the vehicle. And so that's pretty significant if you stop and think about it. We can come up with any kind of hypotheticals. My college kid's off doing something they're not supposed to do, in-state, out-of-state, whatever the case may be. But why would I be on notice of that? And as an innocent owner, there's no innocent owner provision in the law as it is. So without that innocent owner provision in there, perhaps the only thing that's saving it, respectfully, is the fact that the owner is on notice that the person that they have allowed to use their car has been previously convicted. That previously convicted, I would say, is a hugely important aspect of the law as it currently stands. I personally would prefer the law to say that once you're convicted, then the punishment of forfeiture would take into effect. That's not what the law says. The law says we can seize it as a matter of civil forfeiture, which is a pretty expedited process and certainly favors the government, but it does require that person have been previously convicted. So you're convicted, car's not necessarily forfeited, you're operating the car a second time in violation of the law, and at that point, now all of a sudden, your car is subject to forfeiture. Well, you can see that makes more sense in some ways because at that point, the owner of the car should have known, well, this person I'm giving the car to has already been convicted before, and so you deal with the innocent owner. So I'd respectfully submit that you not change it, take out that that requirement that's in there right now that they be previously convicted. I know this is not on the table. I will take it a step further. Probably, I think, if we really want to get effective, what you want to do is look at the statute itself for this crime and look at changing things like forfeiture in that context, either as well or in addition to. But I think, respectfully, you should keep the law the way it is. In fact, I think you need to avoid undue fairness of the owner of the vehicle.
Also, I'm sorry I didn't say, Representative Neal, people don't get their property back. Once it's forfeited, it's forfeited. And so unless they qualify for the hardship provision, either the police department has put that car into service somehow for its own fleet, or they've sold it to benefit the state. There's no getting the car back if someone is adjudicated as not guilty of these offenses.
May I add one thing? One other thought, following up on what my colleague just said here, is the general time frame for a civil forfeiture is 60 to 120 days. So if you're thinking about the time it takes a case to get through the judicial system, certainly in the metro area, that person may or may not be convicted of what they've been accused of, and yet that car is long gone through a civil forfeiture proceeding, which is just a preponderant standard and not a proof beyond reasonable doubt. Thank you for allowing me to speak.
Thank you.
Representative Roberts.
I just want to clarify because this is not my area of the law. Because originally I thought, well, could we change the language? Because I understand the concern that you're taking the car before the person's actually been found to be guilty. So changing has been convicted doesn't solve the problem because you're saying an owner wouldn't have noticed that the person that they let and their car is taken and forfeited if someone else is operating. Is that what your concern is?
I guess what I was trying to express, I may not have done it very artfully, is that as it's currently written, first of all, there's no innocent owner provision, which is normally exists in all forfeiture proceedings. Okay. What there is this hardship provision that allows that the person to get the vehicle back, right? But the previously convicted, as is in the current law, at least arguably puts the owner on notice that the vehicle they've allowed someone else to operate is subject to this law.
But I can imagine, couldn't there be another circumstance where it's not the family that was the owner and it was some other third party that owned the car and allowed someone to drive it, and then they're losing their car based on the behavior?
Absolutely, yes.
And not even the convicted behavior, is that?
Correct, that's the problem. And if you have like a history, hey, I'm giving my car to someone who's already been convicted, you're at least arguably on notice. Be careful who you give your car to.
Thank you for the clarification.
Yes.
Number 6.
Thank you to the chair. Quick question. So the two recommendations you all have is, of course, post-conviction being included and then an innocent owner provision, correct?
Well, in order to effectuate those changes, that would be a restructuring of the entire forfeiture code, which we would be happy to come to the table about, but I don't think you're going to do it in this bill, with all due respect.
Even if we include something that says, for the purposes of this section, this applies. I'm just asking, just curious. I'm just tossing that there.
I guess it's possible. I just think it's a bigger can of worms to try to restructure forfeiture. I think our most practical suggestion is that you hold off on passing this bill. that by taking that recidivist piece out of this legislation, you're taking away the one bit of notice that a person has right now that hasn't even been tested by the courts to see if the behavior can be deterred through enhanced punishment, which we join our friends at the Southern Center, which, I know you guys sound like I think I'm beating a dead horse about this, but it's the chance of getting caught that's the most deterrent thing, not increased penalties. Although I do understand that if word gets around that someone took my car because of this conviction, that could change something for some people in that person's orbit. But we don't even have that yet because we don't have these cases all the way to adjudication based on your most previous updates to this law.
So you don't have a recommendation to fix the current form?
Then I would say at line 10 to say who is convicted of a violation of this code section would be my suggestion. Might need a little help from
But that would
legislative
fix
counsel
your
with that.
initial issue. The initial issue would fix.
If forfeiture followed conviction, I think we would have we would have a lot less to say here. But given that not only is it preceding conviction currently, but now this idea that it doesn't even have to be recidivist behavior that someone could know about. It's just you got arrested and charged, and now we're going to take your vehicle. Yes, please.
For instance, just tossing out an idea, you could say any motor vehicle operated by a person who is and then arrested and convicted of a violation of this code section, and keep on rolling from that point forward. That changes it from its current law. Current law is you're previously convicted, you get a second bite of the apple. What I've just said changes it to one bite of the apple, but it's a conviction bite as opposed to a mere allegation bite.
We'd be in for 2 bites too.
So line 10, keeping what we have, replace charged with convicted.
Who is
Arrested.
arrested and charged
And convicted.
With convicted.
Convicted.
Striking, arrested, and charged.
Convicted of. You would strike arrested and charged with, and put who is convicted of. And we could all debate. If you want one bite at the apple, you leave the strikes that are there. If you're willing to keep 2 bites, you would make plain who has been previously convicted of a violation of this code section and in addition to the other change.
Okay, I got it. Thank you.
Thank you.
You still want to bite? All right,
Everybody's biting apples in this room. I figured I ought to get my chance too. So, currently, the state of the current law is if you have one conviction, then your car is subject to forfeiture if you're arrested for a violation of that section. All right, and so that's the current state of the law.
That's right.
All right, so and maybe this is my question to the author, and I apologize. There's nothing like running into the last minute of a hearing and asking a bunch of questions that have already been addressed. But is it the author's intent to provide that upon arrest the first time with no previous conviction and before conviction of that first charge, the motor vehicle would be subject to forfeiture?
Oh, sure. I'm sorry. I'll move. No, come on.
And thank you for your feedback. Could you restate the question?
So I'm trying to determine, and I'm sure you probably made this clear in your presentation. Is it your intention to provide that upon arrest the first time your car can be subject to being forfeited, or upon arrest the first time after conviction it could be forfeited and you don't have to have the previous?
I'm amenable to the conviction upon the first time. The intent is to add another layer of deterrent and to focus on the vehicle as the vessel.
The vessel.
As opposed to the
deter.
participation in the behavior. Yes, sir.
And so that I just wanted to clarify that. I guess my question would now be for the previous witnesses.
I'll
If
turn
I
you
may,
on.
Mr. Chairman.
What number is that one?
17.
All right, go ahead.
So under current law, this current law, the statute that is proposed to be amended in Representative Willis's bill, it allows for forfeiture based on an arrest if there's a previous conviction.
Current law does, yes.
So it does not require a conviction as the basis of a forfeiture.
Right.
And
I mean, except the previous one.
The previous
of
one,
course,
yes.
But yes, but the current, but as it is today, so like there could be people right now who were, as of, whatever, it would have been July 1st, 2024, had previously been convicted. Actually, no, though, because you can't be, so at the time they were convicted, this would not have been the law. So it would have to have been a conviction that occurred after. So you have to have, right now, you would have had to have that first conviction occur post July 1, 2024.
Because otherwise you don't have notice of what can happen.
Right.
Yeah.
And then you'd have to be arrested again. And that's what I was saying. We just haven't had time to get there.
To see what the impact is.
Right, because we don't even have the first round of convictions yet that would substantiate then the forfeiture upon the next arrest.
So I'm assuming has anyone argued to your knowledge that it would be unconstitutional to forfeit a vehicle based upon an arrest before determination of whether you've actually committed the crime the second time?
Well, I can't speak to that particular scenario, but I know that it is routinely argued in civil asset forfeiture cases. The concern about a pre-conviction forfeiture of property happens not only in this context, but in many contexts in our state.
Yes, and that's what I thought.
It is an ongoing problem that has never been addressed here. It's a very sticky wicket, as we call it down here.
But I gather there are other contexts in which assets can be forfeited based upon an arrest, statutorily?
Yes.
Okay. And as to the innocent owner defense, is that not in Chapter 16 of Title 9 already?
It would be.
Okay. So you've got that. Even with this language here, you currently have that. I guess your argument is you don't have it if you don't even have a conviction and you're having the asset forfeited?
Well, yeah, I just think the way that this, correct. I think the way that this current statute is written, which makes only this hardship provision, it creates a great deal of uncertainty as to the innocent owner. There is a general innocent owner in the Georgia forfeiture statute. That is correct.
Okay.
So my concern there is, once again, is kind of the Southern Center attorney or person that's spoken to is kind of rapidly been changed over a short amount of time without really giving time to see if any of these changes are effective. And you're now creating a situation where someone operating a vehicle without having been actually convicted of that is being put into this civil forfeiture process, which is a tough place to be, particularly when your criminal case has not been adjudicated yet, and you're not a recidivist. I mean, we often treat recidivists differently. This is first time through, and your car is gone within 120 days.
Mr. Chair, may I make a point of clarification? So, with the representative's proposed amendment to what we initially introduced, upon seizing upon a first conviction, what this would do is allow us to at least hold the vehicle pending the adjudication of the case. And obviously, if it was adjudicated not guilty, the property would be released back to the rightful owner. But with the amendment for first conviction, it will allow us to hold that vehicle and then go through the asset forfeiture process if that is adjudicated guilty in court.
Thank you, Mr. Chairman. And
Yes,
thank
sir.
you, everybody.
Just to be clear, there would have to be language added to the code to have that holding of property requirement. There's not a holding of property requirement in our code right now, and that may be the ordinary practice of the Atlanta Police Department. I can't speak to that, but that is definitely not the ordinary practice of every law enforcement agency around the state that is.
And it's not statutorily prescribed.
Right.
Correct. Yeah, you seize and forfeit the seizure. I mean, but the forfeiture title goes to the state, and there's no coming back from it.
Representative Panish, I think I'd turn you on over there. Or no, that's 12. Go ahead.
Thank you. Yes. Let's assume the bill is enacted the way it is, and a car is involved in this. The car gets, or the driver gets arrested or cited. The car then goes through the forfeiture process, which is a process which has due process protections to it, right? So there are civil guardrails because it's more of a civil system. Mr. Hall and I know each other from handling federal cases many years ago, even as co-counsel on one of them. I think his client flipped on mine, but we can discuss this a whole other day. But we're not the Wild West in that the car's not taken upon arrest and sold and without some levels of protection becomes the property of APD or anyone else, right? It just shifts. This is now a civil proceeding, pre-conviction, which has its own types of due process. Is that accurate? And you don't have to answer it yourself. I mean,
there are due process provisions within civil asset forfeiture, yes, but it is. We can imagine a scenario where, especially when you consider the truncated timelines that process does unfold in, that a person that's arrested and in custody during the duration of that proceeding, although we would technically as lawyers say that they were allowed due process, probably feels pretty different to someone who's incarcerated while they're trying to fight to keep their property than it would if it was someone, say for instance, even just on bond. So we're talking about the time so soon after someone's arrested for a charge like this, where the proceedings would unfold and the property potentially taken from them. We stand by our hope that this body will one day find its way to not taking people's property until they're convicted.
well, I mean, I understand that, but that happens in lots of other cases. If the person's is incarcerated and they have a civil case, there's no civil right to be present. I mean, that's up to the judge. I'm not saying it's correct. I'm just saying that it occurs. This is not the only type of case where civil forfeiture or somebody's in jail at the time of a hearing on a civil matter. Okay, thank you.
Okay, number 14, Whipper Chip.
Oh, I wanted to ask the lieutenant one more question. In these arrests that you're making with these cars, and they're all souped up, I mean, how many of those are mom's minivans?
Almost none of them.
Yeah, that's what I was thinking. And at the appropriate time, Mr. Chairman, I'd like to make a motion. I think the author has said that she is amendable to a post-conviction asset forfeiture. So at the appropriate time, please let me know.
One more question, Mr. Whip, and I'll come back to you. I think you read the room the same way I did about 15 minutes ago. Number 17, Chairman Crow.
It's me this time on mic 17. Thank you, Mr. Chairman. I missed the days of Chairman Leverett and I sharing a microphone, so
Yeah.
maybe later. Just for clarification, and I understand the amendment and would not be opposed to the post-conviction forfeiture, but Lieutenant, did you say earlier that having the language of arrested and charged with violation allows you to hold the property because it's subject to then? If we change this to after conviction, would the vehicle then have to be returned while the case is adjudicated? And then if there's a conviction, then it would have to be seized and forfeited?
Sure. Just to clarify this statement, so if we make an arrest for someone for street racing, we hold it and it goes to impound under normal circumstances. They can theoretically pick it up within 1 hour. With the provision to allow us to have a potential for asset forfeiture, we can hold it for the duration of that process. And whether it's found to be seized by the government or to return back to the rightful owner, allows us to at least hold on to the vehicle for that time period. That's more of what I meant, and I'm sorry if it came out of the way.
No, that's fine. I wanted to make sure if this language gets changed to arrested and convicted of, is that going to then, will they still be allowed to hold that vehicle? And if not, by the time this case gets adjudicated in a year, 2 years, maybe 3 years down the road, are they going to be able to locate that vehicle, reclaim the ownership? What if it's been sold? You know, I'm curious about that, and I don't know the answer, but it is a question because I know that being able to hold on to it is, that creates another problem with my friends over here to my right who are so graciously sharing
Representative
a mic
Hong
with me.
has a little bit of wisdom on this matter.
Please.
Thank you, Chairman. So having listened to everyone's concerns, I understand the concern that we want to be able to hold the vehicle, yet I understand the fairness of not having a conviction before it is forfeited. So with potential on line 11, so leaving all the language that you've changed, Representative, but on line 11 after forfeiture, so it would read, with a violation of this code section is declared to be a contraband and subject to forfeiture after conviction in accordance, would that allow you to hold the vehicle, and then if there is a conviction, then it could be forfeited?
So during that asset forfeiture process, when the paperwork is filed, it would just be for that time period, just until it's adjudicated in civil court.
I'm sorry, can you repeat that? I don't understand what that meant. Yes.
So the answer would be yes, just for that process while we're in we file the notices to seize it in court.
So meaning, and maybe I'm just not understanding you. So would that allow you to hold the vehicle and then after conviction be able to keep basically go through the forfeiture process, if I put that specific language in where I'm proposing it?
Yes, I believe so.
Okay.
Robert will pack. Robert Smith, can you come on?
Thank you.
And I'm going to lead off with a question from right here at the chair real quick. If one of y'all, if y'all just scoot over. And Robert, I'll just kind of line up a little bit of a straight fairway shot for you. You've heard the hinted amendment coming to this legislation. My question would be, if vehicles impounded subject to the investigation.
I want to make sure everybody understands, first off, that the way this is drafted, and I want to make sure everybody hears this clearly, y'all have already put into, and as has been suggested, and I want to make sure everyone understands, the innocent owner standard applies. That's OCGA 9/16/17. Anytime the state attempts to forfeit anything, the innocent owner has the right to come forward and be able to demand the property back in a civil proceeding. If we shift, and right now how asset forfeiture works is that instrumentalities, proceeds, those contraband is seized at the time of the arrest, and then as been stated, it becomes two separate processes. There's a civil process and a criminal process. If we were to split them and say that the civil process cannot go forward until after there's a criminal conviction, it means that the state has no proprietary interest in the property. It can't be contraband, because how can it be contraband without an adjudication beyond a reasonable doubt that in fact it is contraband? So the two things become, and if you want to say at conviction, if you want to say wait until conviction, when is conviction? Because conviction is not when we say guilty or a plea of guilty is entered, but as we open records say, it's not through the first direct appeal. So take your 3 years. Let's say we have a fast track trial, and let's keep it here in the Atlanta Judicial Circuit, where you heard earlier about needing a 21st judge. 3 years to get to a jury conviction. Another year or two to be able to get past the motion for new trial, because after all, in this state, the only way to get a conviction is through ineffective assistance of counsel. So we have an appeal. We go to the Court of Appeals. We go to the Supreme Court. So now that souped up car that was used in this process, not the Honda Odyssey, but one of those cars that's got all the things to it, which, let's be honest, and I think the lieutenant would agree with me, usually they're not owned outright. Some of them are, but for the most part, there's a lien. There's somebody who's got some other interest in it. So now we're going to go 7 years, and then the state finally be able to go forward and say, hey, we'd like to forfeit that property. Good luck finding it. Good luck saying it has any value, because that's the other thing too. The reason why assets are forfeited is because they are assets, because they can be converted into something else. Vehicles that old no longer won't have the asset, won't have the value to them. It's no different than if I were to forfeit, a fungible item, like something like food or something like that. It's going to be spoiled. A vehicle will have diminished value so much it won't be worth the effort to go forward with it. So, don't make this the only forfeiture that's post-conviction in the state. Keep it in line with everything else. Keep using the language that you've already approved with the innocent owner standard. And whether or not you choose to go this, that's a policy decision. I just want to make sure that you know what the law is and why y'all have told us to do it the way we have and have told us to do it for years.
Lighting up like a Christmas tree over here. Number 11.
Thank you, Mr. Chairman. So, trying to understand how to interpret what you've just said in terms of what action we would take here. I think the sponsor's desire is to provide that upon arrest, the car could be held, and then upon conviction, if there is a conviction, the forfeiture proceeding could occur, or the forfeiture order could be entered. Are you saying that's currently the way that procedurally it happens under current law?
How it works right now is somebody has a prior conviction, then they get caught doing reckless street drift, whatever the crime is, a second time, the car is then seized. They and whoever is the owner of the vehicle get a notice that the car is going to be subject to asset forfeiture proceedings. And then there's a civil case. While the criminal case is still yet unadjudicated, there's a civil process. Now, the defendant or the state has a right to come in and say, hey, can we put this civil proceeding on hold until the criminal case is over? And in some cases, we do that. But there are, because obviously may not make the most sense to subject a criminal defendant to a deposition about their activities in regards to the vehicle. I mean, there is a Fifth Amendment, after all.
Well, but what I'm asking is, it sounds like you are saying under current forfeiture law, upon arrest, just like the defendant, although they're presumed to be innocent, they can be arrested and held until they bond out. The asset, if it's alleged to have been used in a criminal enterprise and satisfies the conditions of the forfeiture statute, can be held at that point. You don't have to wait until the conviction to pursue the forfeiture case.
That is correct. We can start the civil forfeiture proceeding immediately, and while the criminal case is pending or not pending. A lot of times there's a pause, but if no one wants to take an interest in items, like say we've got this car and all of a sudden the defendant who is driving it says, oh, it's not my car, nobody else comes forward, we can go ahead and move to a forfeiture proceeding.
So before I forget where we're going here, my understanding then from what you're saying is lines 9 through 12 as currently proposed in the bill would allow law enforcement to hold the vehicle upon the first arrest, although it isn't necessarily forfeited. There still has to be a forfeiture action, but they could hold the vehicle and initiate the forfeiture action while the charges are pending.
Yes.
Subject to forfeiture, but the forfeiture doesn't happen until you get the order in the forfeiture case.
Correct.
So I suppose if the desire of the committee is to allow the car to be held pending and just allow a forfeiture to happen, the language as proposed by the sponsor would achieve that result. If we want to make it after conviction, that apparently is an aberration in the forfeiture process, but we could do that by the language that's been proposed.
Yes, sir.
In other words, you don't need some additional language to allow holding of the asset. That already can be done once the arrest occurs. And does some notice of intent to forfeit have to be provided? Or
yes, it's a civil proceeding. It requires a process. It has to be personally served. If we can't find the owner, we have to publish it in the newspaper or the other legal organ. It is a process. Having done asset forfeiture on vehicles where banks were involved, it becomes really interesting.
But you got to notify everybody with an interest.
And all kinds of lawyers come out of the woodworks wanting to tell you that you don't have a right to forfeit it.
Okay. All right. Thank you.
Okay, I've got some big hitter bills still to get to, so here's what we're going to do. I appreciate that very much, Mr. Smith. I'm going to go ahead and move over and let Representative Willis have the last word, and we'll let the committee decide what they're going to do.
Thank you, Mr. Chair, and thank you, committee. I know this was long. But I do appreciate all of the feedback because this is a serious decision. The intent of this bill was to add an additional deterrent to a raging issue in the city of Atlanta and Fulton County. Rings of fire, disruption of major events, which we continue to have forthcoming. So I just want to express to you that that was the express intent of this bill, was to add another layer of deterrent to a behavior that is a public safety issue, plain and simple. I appreciate the feedback. I expressed amenability to post-conviction language. I understand that and receive it, and just wanted to circle back. And lastly, wanted to say, I met with the city of Atlanta. I met with the police department, and this is an issue that both the governor and the mayor have expressed needing greater layers around, and that was my pure intent. And I thank you for the opportunity to present to you.
Welcome to the NFL. Number 12.
I have a motion.
All right.
I move to pass.
Move to pass. Second. Mr. Whip, you got
I was going to second, but yes, I'd like to, when you move into the amendments, I'd like to offer an amendment.
All right, that'll be now.
Mr. Chairman, I'd like to look at lines 10. What did we say there?
Arrested and convicted.
I'd like to strike the word charged, add convicted, strike the word with and add of. So the sentence would read, who is arrested and convicted of, no, don't strike of a violation of this code section. That'd be my amendment.
Okay. Got a second. All right, I got y'all out now. Do y'all want to talk about the amendment? Is that what you're? Okay, Chairman Crow.
Thank you. And I understand and like the amendment, but I think that is contrary to everything Robert just told us. That Robert just told us if we do that, we're going to make a big mess of things by declaring something is not contraband until after there's a post-conviction, and I think that'll mess up a lot of other things in our civil forfeiture code.
Let's get Robert back up here.
We need to get Robert a permanent chair.
The one with wheels on it.
Yeah.
You first gotta get a traditional looking table.
Go ahead, Robert.
Robert, isn't it true that we've had this discussion about civil asset forfeiture for a very long time in this committee?
Not just this committee, but yes, sir.
Yeah. All right. Isn't it also true that by and large, the majority of folks that are utilizing civil asset forfeiture, they are waiting till after conviction to forfeit those assets?
I don't have the information to be able to accurately answer that question.
Isn't it true that it's possible to utilize civil asset forfeiture after conviction?
That is true.
Okay.
It's also true you can do it before.
You can do it before. That's correct. Isn't it true that you're innocent until proven guilty?
That is a true statement.
All right. So my concern is this: we have had this discussion for a long time now. This specific legislation right here will only be pertaining to this specific crime. Isn't that true?
Yes.
Okay, so this doesn't bleed into any of the other civil asset forfeiture. This change on line 10 doesn't change it for anybody that's racketeering or anybody that is, subject to many more civil asset forfeiture crimes, correct?
This would only impact the reckless stunt driving.
Reckless, so drag racing.
I think that's a different crime, sir.
I'm sorry. So what'd you call it? Any person? Reckless stunt driving. Okay. So drifting. Is that what we're talking about? Okay. So this is only specific to this area, right?
Only to this specific code section, this forfeiture proceeding, yes.
Okay.
Chairman Crow.
Okay. I think that answers my question, but it brings up another question in that if you mention that there's already typically the civil forfeiture is already waiting till after conviction anyway, I don't know why we would need to change the language in here to do that. I think we could just leave it as the bill was originally written.
Robert, have we had any issues where we've had some pre-conviction asset forfeiture that then it turns around that the person was innocent.
Yes. Can I clarify?
Yes.
It was the incident I can think of was specifically involving the coin-operated amusement machines, where the Court of Appeals changed a definition to something that was different than the way we understood the law at the time.
That's the case I was talking about.
Mr. Smith, thank you again.
I didn't sign up for this bill.
I know you did. Thank you. All right.
I don't feel. I mean, I think that from a policy objective, I think that we should go post conviction. Now, I don't want to put the representative's bill in jeopardy. If she wants to leave it like it is, that's fine. But I think this is a good policy objective to do it after conviction. They will have to hold the vehicles, which if you've been to any of these impoundment lots, some of these vehicles are being held for how long now, Lieutenant?
There's some for quite some time.
So I get that there is a decrease in value, but if she wants to hit this with a hammer, it's take the car upon a conviction. I guess it could be argued that if you take it as arrested or charged, then it's even harsher. So whatever the will of the committee is, Mr. Chairman.
Okay. All right, got a move and a second on the Burchett amendment. All those in favor say aye. Aye. All those opposed, same sign.
No.
All right, ayes have it. So, all right. So we got a move and a second with the Burchett amendment now on there for House Bill 1390 LC 394974. All those in favor of the bill as amended say aye. Aye. All those opposed, same sign.
No.
Congratulations, you're on the rules.
Thank you. Thank you to the committee.
Okay, all right. Representative Karen Lupton, House Bill 626.
All right.
Good afternoon, Representative.
Good afternoon,
You can
Lady Chair.
move forward when you are ready.
Absolutely. Hi, everyone. This is pretty much the exact same bill that was passed out of this committee last year. It died in rules, so it has been resurrected once again in this second year of the biennial. I'm reading off of LC 481769S. There was a change made in subcommittee that struck on line 7, 2025 and made it 2026 because the year has passed. This is a bill that involves 7 words. If you look on lines 15 and 16, we strike not less than 12 months and we add 30 years. This Georgia has an excellent system when it comes to tracking our rape kits. When rape kits are taken at emergency rooms, sexual assault centers, they are immediately put into our tracking system. That tracking system is excellent. In my research, I found that Georgia is way ahead of a lot of other states on that. So yay to us. Now, every kit is taken and every kit is logged into our system. Not every assault is immediately reported to police. There are a lot of different reasons why a handful of people may not feel comfortable going straight to the police. So, with numbers that we get, there's between 2,500 and 2,900 sexual assault kits, rape kits taken in Georgia every year. Fiscal year 23, 256 of those kits did not get immediately reported to police. FY 24, 319 kits did not occurred with assaults that were not immediately reported to police. So about 1 in 10 is not getting reported. Right now in code, those 1 in 10 can be tossed after 12 months, after no less than 12 months. We want to move that to 30 years. States right now have a retention of these kind of kits anywhere from 10 years to 50 years. A kit is about this size. It does not need to be held in any particular refrigeration, any special place. It has some slides, maybe some baggies. You could fit every kit that it does not get reported in a year in Georgia on those bookcases over there. It does not have, as such, it does not really have a cost associated with it. I went out and I asked people, how much does this cost? They said, what does it cost to keep a filing cabinet? What does it cost to keep a closet? I don't know. So this retains evidence that we cannot get back for a period of time that allows for all sorts of circumstances. I have two people here to speak to the bill who have helped a bill like this get passed in Florida. And who, like me, are sexual assault survivors and feel strongly about this. So that's my bill.
All right, thank you, Representative. Any questions? I don't see any questions from the committee. I'll, Ms. Gail Gardner, do you two want to come up together or want to? Okay, sure. No, we heard from both of you in the subcommittee, but thank you for coming back. So Ms. Gail Gardner and Stephanie Sherman, thank you so much. Do you want to get the mic?
Yeah, you can come over this side. There's a mic over here. Go on in here and you can use this mic.
Thank you for allowing me to take these moments. My name is Gail Gardner. I'm not only an advocate and a survivor, but Georgia and Florida have one thing in common, is that rape kit tracking system, and I was named after the one in Florida, where I lived for 46 years, and I've been here for 3 years, Gale's Law. I have taken time through the years to advocate for survivors before there ever was a Gale's Law, because for 30 years I didn't know where my rape kit was or whatever happened to my case. And I happened to go into the police department for a moment to find out about my case so that I could put it in a memoir. And I was held for a while because they had actually found out that I had a cold case, and I made local and national news. The point I wanted to know was, why wasn't I contacted all those 30 years? They had people that actually helped keep him in jail, and then as soon as they would put him in there for 45 years, he was back out on probation and did some more. He was known as the Malibu rapist. He was a serial rapist in Orlando, Florida area in the black community. I was determined that he was going to actually see my face in court. And so on the September 18th of 2024, I had the opportunity to confront him. He had been in prison since 1992. No one came. I have the joke, one of the organizations that helped with this case brought it to attention for the backlog case, as far as looking for how many rape kits are still sitting on the shelf without being tested. And that was Joyful Heart Foundation and some others. Well, that campaign that they did, I kept looking for Olivia Benson to show up to my door, who is actually the founder of Joyful Heart Foundation. And that's just my joke, whatever happened. Nobody ever touched me. But I'm beginning to figure some things out why. The one thing I didn't care for with the survivors, and when I met Stephanie, and she had asked me about her case, what could she do? I didn't know at the time because I was still reeling from this whole situation. But what actually got me concerned was that she's not the only one, and there's so many others. My culture and mostly females are very close about holding families accountable for things they don't want to be they try to be the peacemakers, so they don't talk much, especially my generation. Thank goodness we have a generation now that's used to be 1 in 3, now it's 1 in 6 who are talking and telling what their story is and actually holding people accountable. And so with that, I have dedicating my life, and I say my life, but now I'm heading down in that area. I'll be 79 this year. It's just to make sure the next generation does not have to go through this, and never again will we see this happening. Now people say, well, that's cultural. That's just the way it is. It's been going on since ancient days. It does not have to, and I believe if you put enough billboards up, and if you just speak more and talk about it more, this will stop perpetuating to the point people will stop doing what they do and protect our children all the way. Thank you.
Okay.
Okay, see no questions. Thank you very much.
Do you want to change chairs? No, that's fine.
Go ahead.
Yes, my name is Stephanie Sherman, Copewood Sherman. I was brutally attacked in 1993 in front of my children. They was ages 3 to 1. At that time, this happened like 33 years ago, but we're here now, and they lost my rape kit. I done a rape kit, and so for evidence inside the court system, they couldn't find it. So we came up with the Stephanie Sherman Act so that it will, what we're asking to propose that this committee agree on a non-partisan basis that an anonymous survivor should not be forced to decide within 12 months whether to seek trauma treatment or live with it, but instead be allowed to make this decision when they are ready.
Thank you very much for coming and sharing with us today.
Yes. Thank you.
Is there a question? Representative Holly.
Thank you, Mr. Chairman. Thank you for coming today and be able to tell that, to be able to tell from your experience. I was just curious, by providing this to extend beyond 12 months into that 30 years, would you agree that not only does this provide for the case to be resolved, but it actually allows for the victim to be able to fully get some closure on this case so that it's not out there?
Yeah, could I speak to that
Yes, ma'am.
also? The trauma is lifelong. It doesn't go away. You just learn to manage it. That's all. And it takes a while. I actually was with a 9-year-old child at the time, and who is now be 48 years old this year. And the one thing that I realized is that I was able to actually put myself through college, put myself through education, educator, and do some things, but I had to learn to manage it. And I would always think that somebody was behind me, or his last words were always with his victims were, "I'll come back if you tell anybody, or if you call the police, I'll come back and kill you." That was in the paper. That's what everybody heard. So I believe that, and that's a terrible thing to live with. So it takes a moment for somebody to say, you know, I'm a little tired of living like this, or you have a marriage situation and you got a frigid wife. You don't know why, but you know something's wrong. And those are the things that happen and break up marriages. And so it takes a moment, but it may never happen. My generation don't talk about it. Not going to do it. That's just not it. But at the same time, we're so grateful to the younger generation who actually sees that there's things that's in place for them and that they can live through this. So just being able to take 30 years, it might not take that long. And hopefully not. In Florida, it's 50 years. And the whole idea is so people can get to the point that they will report what is going on in their life and is it worth it. And there were 7 people who were on the list. He raped over 150 people over a course of 1974 to 1994, I think it was 1992. And the one thing that they had on file was that he actually caused some problems because of the children. I'm thinking about Stephanie's children. Yes. Children have to live with this. They thought Stephanie, if I could tell this, Stephanie was going to die. He stabbed her multiple times, even in her face. Stephanie was actually on the doctor's show for getting her tissues and everything in place. But he ruined, and all of those ruined. And so she had to go through this with her children who were there and watch them. And she pretend she was dead in order for him to stop stabbing her while he raped her. So we don't want that. We don't want that in our society. We're tired of that.
Thank you. Vice Chair Hall.
Move to pass.
All right, I got a move to pass. Second. All those in favor, say aye.
Aye.
All those opposed, same sign. You're on the rules. Okay.
Thank you very much. Thank you very much.
Next up, we're going to hear House Bill 1196. And I'm going to present from right here, unless anybody has any objection. 1196. Okay, if everybody recall, it was either a year or a couple of years ago, we had legislation dealing with criminal trespass. Apparently, we've had situations of those at different zoos across our state. I know everybody thinks of just the one here in Atlanta, but even though I loved that as a child, there's more than just one here in the state. And so that was actually back in 2024. So as far as what this would do, it would actually update what we have previously done for criminal trespass for someone who knowingly causes a foreign object to enter an animal enclosure, and if an individual was to interfere with the operation, functionality, or integrity of a cage, enclosure, or other area where a wild animal is housed or otherwise contained. That, in essence, is what this does. Now, those of us that are learned members of the bar may say that, you know, we thought criminal trespass already covered this. Well, again, the coloring book we have to get out every now and then. So, as bad as I would hate to do it, we're representatives and not judges here. So, no offense to our judge that's with us today. I know he does a fantastic job. Just wanted you to know that, Judge. So anyways, questions from members of the committee? Brian Hudson, you're signed up to speak. Come on down. And I'll come back if y'all got questions for me.
Which one of these?
Either one of them.
All right. Thank you, Mr. Chairman, members of the committee. My name is Brian Hudson, and I own the Hudson Group, government relations firm, and I have represented Zoo Atlanta probably since about 2007, 2008, something like that. As the chairman mentioned, we worked a few years ago with this committee as well as the Senate, and the governor signed legislation that was really became monumental worldwide. And I say that because we were the first to do it. Georgia was the first state to pass this law, and I think it has worked very, very well. And we have received a lot of interest from zoos as far as San Diego to Berlin to Australia, as far as wanting to model Georgia's law to protect their animals. And so I think one oversight that we had, and I think thanks to the chairman and Representative Tanya Miller, who actually represents the zoo, she's a great partner in this as well, amongst others, co-sponsors that have facilities in their districts, was the growing trend of patrons throwing objects at animals. I know it sounds crazy, but it's happening. There was a situation in Memphis where a patron threw a shoe at a Komodo dragon, and the dragon ate it, and they had to have emergency surgery on that animal. And that's it sounds ridiculous, like childish, but it's the type of behavior that we're dealing with. And I will say, just from our standpoint from Zoo Atlanta, since the law passed 2 years ago, we've invested over $281,000, which is a lot of money for a nonprofit, in improving the facilities, specifically those with dangerous animals like lions and tigers, clearly. And so we are hoping that I walked right into that, didn't I? Thank you. Thanks for not picking on me. Oh, I can always count on my good friends. But we, in all seriousness, we did invest over $280,000 to improve these enclosures, and this will just make that law that much stronger, and hopefully will continue to be a model for not only the United States but the rest of the world. So, thank you, Mr. Chairman.
Some of these were lighting up before Brian got up here. Are those questions for him or for myself? Okay. Okay. All right. All right. We'll come back once we get another member back.
Yes, sir. Thank you.
Is anybody else
Thanks, members.
signed up to speak to this? Gagna Pack. All right. There we go. Okay. Now I'll entertain your motion, Chairman Crow.
I'll move to pass.
All right. Move second. Chairman Hong.
I have an amendment, Mr. Chairman.
Go ahead.
Just so that it reads well, on line 25, before any, I'd like to include such term shall not include, and change the A in any to a lowercase. So such term shall not include any domestic animal. And then on line 27, starting with the word shall and ending with definition on line 28, strike shall be excluded from this definition and put a period after science on line 27.
And the author takes that as a friendly amendment. All right. You hear the hung amendment. All those in favor of the hung amendment say aye. Aye. All those opposed, same sign. Okay, seeing no other amendments, all those in favor of the passage of House Bill 1196 LC 481662 with the hung amendment will say aye. Aye. All those opposed, same sign. Congratulations, I'm on the rules. Okay. Bear with me a minute, members. Real quick, I'm going to do this on behalf of Representative Stevens. This is going to be House Bill 1329 LC 650071. Members that have been here for a little while or even one session will remember this is a update to our scheduling statute here in the state. And this is what we do every year to make sure that we are in compliance with federal code. Trying to see if I have anybody signed up for this one. I don't know that I've ever had anyone signed up for it. Gackel Pack, anybody want to take a bite? All right, seeing none. Number 7.
At the appropriate time.
I'll entertain that time right now.
Motion to pass.
Second.
All right, move in a second. Do pass. All those in favor of House Bill 1329 LC 650071 say aye. Aye. All those opposed, same sign. All right, that's on the rules. Okay, there's a quick update, real quick, just for some house. All right, so just for clarification, we've had to move 2 into Wednesday. We're going to move House Bill 1282 and House Bill 1154 to Wednesday afternoon. That may be a long day, but we will endeavor to persevere, as the outlaw Joseph Wells movie said back in the day. That's your homework for tonight if you've never watched it. Let's see, is Representative Gamble with us? All right. Those of you that have been in the crowd needing a restroom break, we're going to stand at ease for 10 minutes.
What'd you say, watch? Huh? What we gonna watch for homework? Yeah.
Outlaw Joseph Wells.
Oh, yeah.
Yes, sir. Go get your switch fine. Trey, if you want to go ahead and present it. We'll come. Yep. All right, we'll come back to order and go ahead and have you present the bill. So go ahead when ready.
Thank you, Mr. Chairman, members of the Judiciary Non-Civil Committee. Great to be with y'all today. In my 14 years, I've never had the opportunity to present a bill to the Judiciary Non-Civil Committee, but I know y'all spend a lot of long hours in here, and I certainly appreciate the work y'all do, despite me not getting to be a part of it until today. But what we're bringing before you today is House Bill 1303, working off of a substitute LC 48177S, which deals what I was trying to do, and I'll tell you the impetus behind this legislation is I have a cousin who is interested in both the political process and is a law enforcement official in Floyd County, one of my younger cousins, and he said, Trey, we have all these child endangerment statutes for that apply when someone is consuming alcohol around a child, but we don't necessarily have that for in their driving through DUI, but we don't necessarily have something that relates to someone possessing or using controlled substances in the presence of a minor. And so that's what we have before us today, is that it would add on a child endangerment statute for individuals who knowingly possess or have under their control a Schedule I controlled substance, a narcotic under Schedule II, or marijuana while in the presence of a child under age 14. It tracks the same penalty that's in subsection D of Code Section 1612.1. It's a fairly simple piece of legislation, Mr. Chairman, and I'll be glad to answer any questions.
Number 7.
Thank you, Mr. Chair. Generally, I think the bill is good. I'm worried about folks that have the legal medical marijuana cards and the low THC oil, how they could possibly get wrapped up in this with younger children.
I agree with you. That's something that I certainly would be open to us trying to clarify.
Okay, thank you.
Number 3. Nice
you.
of you to come back and join us, Kendra.
I had to practice some law. My question is about the age of 14. Why not 16 or 18, or where we get that number from?
That is where I was trying to track what we have, as my understanding, in the other child endangerment statutes. But I'm open to suggestions from the committee.
Number 12. Representative Panich.
So in cases involving domestic violence, if a child is present, then it's a separate charge also, cruelty to children. That's a misdemeanor. I'm trying to look up 1612.1, but do you know what the punishment for this is?
Yes. It is, it's a misdemeanor.
Okay, thank you.
Okay. Okay. Any other questions from members of the committee? All right. Seeing none. Or Representative Roberts.
I just wanted to clarify. I think the first offense is high and aggravated misdemeanor, and the second offense is felony.
In the substitute, on 1612.1, first and second are just standard misdemeanors. A third subsequent conviction would be a felony, but it would take the third, and that's so we had also changed up the provision that would allow each child to be a separate offense. I took that out in my substitute.
Okay, thank you. While y'all contemplate on that, is there anybody signed up to speak to this bill? Okay, Robert Smith will pack.
Everything that got said was what I was going to bring up, other than you also have Schedule 2 drugs that are prescriptions as well. So you need to make sure you bake in some sort of, because the idea is that I'm assuming that the author does not want to criminalize when a parent is taking medicine in front of their child.
Correct.
And that, so and I know that's not what the intent was, but you just got to make sure your drafting has that in it to make sure that an overzealous whoever doesn't scoop up. And by overzealous, it not mean law enforcement, also could be this could be weaponized in domestic or something like that. So, but otherwise, I understand the intent, and that was my biggest concern, was making sure we had that baked in.
Okay. All right. Number 17, Chairman Crow.
Yeah, just to that point, maybe adding something in after Schedule 2, highlighting the fact that in violation of the code, and then after marijuana in violation of 161330, which is, the marijuana statute for violation. So,
okay,
if that's an idea, if some of you more knowledgeable lawyers would like to work on framing that.
I'll tell you this much, Representative Kelly, if you want to slide over, I got a couple more to testify. If y'all want to go over there quietly, if Robert, you want to help out and pack, if y'all want to sit over there and chime in too, please, thank you. All right. Come on down.
Thank you, Chairman and members of the committee. My name is Trip Richardson, and I'm with Frontline Policy Council in support of HB 1303. I'll keep this pretty short. It's been a long day. This bill addresses a serious gap in our child protection laws. Under current law, possessing controlled substance is a crime, but there is no specific accountability when that possession happens in the direct presence of a young child. Children should not be exposed to illegal drugs in their homes, vehicles, or immediate surroundings. HB 1303 reinforces that responsibility and strengthens protections for Georgia's most vulnerable. We are grateful to Representative Trey Kelly for bringing this bill forward, and I respectfully ask for your favorable consideration in support of HB 1303. Thank you.
Thank you. See no questions from members of the committee. Ma'am, do you want to speak on this one?
I could. I mean, it was pretty much said.
Leave it up to you on that.
I appreciate the opportunity. I personally know some folks who have been targeted by crazy exes, and I'm worried that they can have another excuse. I'm all about being a responsible adult around children. I also know folks can definitely be targeted for cannabis, whether it's medical or otherwise. So, yeah, it'd be great if he added that, and it sounds like he's open to it, so I appreciate that.
Thank you. And what was your name again? I'm sorry.
My name is Aviva
Okay.
Vuvuzela.
Okay. Thank you for being with us today.
Thank you.
We're going to stand at these until they finish up on their changes. Okay, go right on ahead, Representative Kelly.
Mr. Chairman's, the three minds that were gathered back there, along with myself, came up with recommending that we put by knowingly. If we move forward to consider amendments, they suggested on line 12, just after knowingly, insert the word and then the word unlawfully. And they think that would handle the prescription issue as well as the low THC card issue. You like that, Holly?
Repeat that one more time. Repeat that one more time, Representative Kelly.
12, after knowingly, we would insert the word and then the word unlawfully.
Okay. Members, y'all have heard the amendment. Vice Chair Hall. Or, I need to move in a second.
I have a motion when appropriate.
All right, I'll take it.
Move to pass.
All right, move to pass. And second, number 13, you got any discussion on that?
I do. Well, not on
Which number are you, 13?
13.
Okay, you, on the amendment or the bill as a whole?
No, the bill.
Okay, I'll come back to you.
Okay.
All right, you've heard the Hong amendment. All those in favor of the...
Did a move to pass, sir?
Oh, yes,
have
move
done
to
an
pass.
amendment.
That's correct. Okay, all right. Any amendments? Representative Hong.
Thank you, Mr. Chairman. I move on line 12, after knowingly, insert and unlawfully.
I got a second. All right. No discussion on that. Moving to second on the Hong amendment. All those in favor say aye. Aye. All those opposed, same sign. All right. Representative Byrd.
Thank you, Mr. Chairman. Just want to go back to your question and the age of 14. Representative Kelly, could you explain why 14 and not 16 or 17? I'm sure there's a definition of what minor is.
It was our goal to track the child endangerment statute as it relates to alcohol. And that was my understanding. That's what that was.
Thank you.
And that's my understanding. But I'm here for the committee.
Okay. All right. No other discussion on it. All those in favor of the passage of House Bill 1303 LC 48-177S as amended with the Hong Amendment, say aye. Aye. Those opposed, same sign. All right, congratulations. The Secretary of Rules, if you'll get me one of them forms, I'll sign it so you can take it to Chairman Parrish.
This was so enjoyable, I may try to come back here a few more times.
Okay. I have not heard back from
Thank you.
Representative Gamble. I'm going to let him know that we're going to move this bill of his to Wednesday. And with that, we are adjourned.
Thank you, Mr. Chairman.